Justices of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. Good morning. Before we begin today's calendar, I would like to welcome, I believe, 11 candidates who will be sworn in this morning as attorneys and counselors at law, and their family and friends who are here to celebrate this achievement with them. I'd also note that present with us today is the Honorable Anthony J. Paris, retired judge of the New York State Supreme Court from the 5th Judicial District, whose son David is being sworn in this morning. Judge Paris, welcome. Ann Dillon Flynn, the clerk of our court, will administer the oath of office. Ms. Dillon Flynn, have these candidates been certified to the court for admission by the appropriate committee on character and fitness as possessing the character and fitness required by an attorney and counselor at law?
Yes, Your Honor, they have.
Please administer the oath of office.
Please stand. Raise your right hand and repeat after me. I do solemnly swear.
I do solemnly swear
that I will support the Constitution of the United States.
that I will support the Constitution of the United States
And the Constitution of the State of New York.
and the Constitution of the State of New York,
And that I will faithfully discharge the duties
and that I will faithfully discharge the duties
of an attorney and counselor at law.
of an attorney and counselor at law
According to the best of my ability.
according to the best of my ability.
Congratulations.
Officially welcome to our noble profession, and I wish you nothing but Godspeed in your what will no doubt be great careers. Thank you very much. We'll begin the calendar. The first case on for argument today, out of order, is case 517, Stewart versus Faith Temple. I believe your opponent counsel is appearing by video.
I believe so, Your Honor.
Give us 1 minute.
Of course.
Counsel Rosen, can you hear us? You're on mute. If you'd be so kind, it's on mute.
Yes, Your Honor. Can you hear me?
We can hear you. If you can hear us, we're good to go.
Okay, thank you, Your Honor.
Counsel, proceed.
Good morning, Your Honor, and may it please the court. Barry Black of the law firm Nelson Madden Black on behalf of appellants. This case should have been dismissed for two reasons.
Counsel, let me interrupt you just for a moment, your argument, and let me ask a question that is that kind of strikes at the posture of the case procedurally. The appeal appears to be from a decision, and the decision makes reference to the need to submit an order. And I'm wondering, I shouldn't speak for the rest of the court members, is this an appealable paper?
Your Honor, I believe the court has already ruled on that. I believe the court by motion had applied corrective measures to adopt it as a decision and order.
In this case?
I could be wrong, but I believe that has been done.
I'm not familiar with that having taken place, and so I'm concerned about this. So absent some prior ruling by this court that I'm just not aware of, if it's an appeal from a decision and not an appeal from an order, where the decision, and we've had cases in the past, by the way, where we have deemed a decision to be in essence an order because it included decretal paragraphs, it had all of the requirements of an order, but it was just phrased as a decision. But that's not the case here, possibly. This is a decision that specifically says that an order is to be submitted, which is different than our prior cases where we deemed decisions to be proper papers to appeal from. So we're concerned about that. I know we're kind of catching you off guard, or maybe catching you off guard. And if you'd like, we would give you the opportunity to do a post-argument submission on that issue.
I would, Your Honor.
Very good. Proceed with your argument then, counsel.
Thank you. Your Honor, this case should have been dismissed for two reasons. First, because both the Religious Corporations Law and the General Council of the Assemblies of God's bylaws constitute documentary evidence confirming that the General Council is a legally separate entity from Faith Temple here in Rochester. In addition, the complaint fails to allege a single fact implicating the General Council. Instead, as the Eighth Circuit recognized, the General Council is more like a bar association which only handles licensing of its attorneys and is not legally liable for the specific conduct of any individual actor. With the court's permission, I should like to begin by focusing on those two forms of documentary evidence. First, the Religious Corporations Law, which in Section 434 sets forth as follows. Local churches, such as Faith Temple, quote, shall be deemed to be sovereign, autonomous, self-governing, and self-determining bodies. Pardon. And the statute says, quote, the affiliation of each church with the General Council is limited to ecclesiastical questions of, quote, doctrine and conduct. In other words, corporate-wise, as far as business operations, they are two wholly independent entities. Should be noted that the General Council of the Assemblies of God is located in Springfield, Missouri, and not in New York. Second, the Constitution and bylaws of the General Council, which governs its relationship with each of its church affiliates, reflects the same sentiments, that it is an entirely independent entity connected only by means of ecclesiastical governance or ecclesiastical rule.
Counselor, if I may, your point here is that the organization of the institution itself is self-directed.
As a matter of,
And those are ecclesiastical matters, how they see themselves and organize themselves.
that is exactly right. John.
And for us to define that relationship would entangle us in the operation of the denomination.
That is exactly correct, Your Honor. However, the court doesn't even necessarily need to become entangled if we read the plain meaning reading of Section 434, which says that Faith Temple, which organized under the RCL, is an independent entity. And in fact, Section 433 obliges Faith Temple to make every decision, including the hiring and firing of its ministers and all business matters, all. So every decision, hiring, firing, including youth ministers that are questioned here, anything they would have been done through the local church.
And the hiring and firing of a pastor is quintessential ecclesiastical matter.
Precisely.
Yeah.
In addition to the documentary evidence in the record, the complaint fails to state a claim under the rules of the appellate courts of this state. The complaint fails to state a single actual fact other than legal conclusions. It is notable, Your Honors, that the entire complaint contains references to literally to the term General Council only in the parties section. So in the section headed parties, they define General Council of the Assemblies of God with all these legal conclusions, that they are an organization in Missouri that does have supervisory authority over the local churches and does have hiring, all of that. But those are just bare legal conclusions. The fact section does not even contain the words General Council. So there's not a single fact actually connecting the general counsel to this local church. That general counsel that sits in Springfield, Missouri. And as such, for both of those reasons, the trial court should have dismissed this. The trial court says in its closing paragraph, well, we haven't yet had enough discovery to determine what that relationship is. But that belies the whole point of 3211A1 and 7. Otherwise, let's not have that statute.
Right, and that itself may run afoul of the First Amendment.
Correct.
The,
For several reasons, including the fact that, of course, as the United States Supreme Court has repeatedly said, government can't treat religious conduct differently from secular conduct. So if we are applying the CPLR in a manner that actually prejudices religious institutions, punishes this church for engaging in religious activity that is protected by the First Amendment by imposing upon them a heavier burden than it does with any local corporation, that would be a violation in and of itself of the First Amendment.
Anything further, Counsel?
No, Your Honor. Thank you.
Thank you. Counsel Rosen?
Yes, good morning, Your Honor. Can you hear me?
Yes.
Okay.
Do you want to address the issue that we raised with respect to the appeal from the decision?
You actually caught me off guard as well. I did not read the order to mean that, so.
We'll grant you a post-argument submission if you wish on that issue.
Okay.
Very
Thank
good.
you,
Thank
Your
you.
Yes, thank you so much.
Proceed.
So I would like to start just briefly with regard to the RCL. I understand my adversary sections on the RCL, but RCL section 426(1), which my adversary didn't talk about, mandates that local churches are also subject to the Constitution and bylaws of the General Council and District. And in this case, I think the trial court properly held that there is no documentary evidence submitted by the defendants to show that this relationship was ecclesiastical in nature only. In fact, the affidavit of Miss Barrett at 205 of the record doesn't even establish that the Faith Temple Church was a general council affiliated church, which would be totally autonomous. She doesn't provide anything except for the Constitution and bylaws, which actually establishes the propriety of the trial court order, because it shows in various sections, and I'm talking about 3211A1 first, please. It shows in various sections that there are many instances where, and I'm going to refer to it as the GCAJ, that's the General Council of Administrative, a General Council of the Assemblies of God, that they have not only a stronghold, but a direct control over their affiliate churches. I'd like to point out two sections, which I think.
Counselor, can I
Sure.
interrupt you? But isn't the very issue here that for us to discern the Constitution and untangle the relationship, isn't that itself an invasion into the denomination's First Amendment rights?
I don't think you are.
The
I'm
right
sorry.
to self-direct and organize themselves.
Well, Your Honor, I think in this case, it's not clear that they're autonomous in that regard, and you're not entangling yourself in a religious doctrine. You can apply neutral principles of law to, this case is about an alleged sexual abuse by a member of the church. This doesn't go to, something that's religious in nature. This isn't about, a dispute that a pastor has with the denomination. This is something that you can apply the neutral principles of law. And I think the reason why you're not getting entangled is by what is actually in the Constitution and bylaws. And that's why I just want to point out two sections that I think belies defendant's argument that you would be entangling yourself in a religious doctrine. I mean, we're not asking the court to resolve an internal religious dispute. I mean, sexual abuse by a member of the church isn't a religious doctrine. So if you look at the bylaws, which the defendant submitted in support of their position that this is purely ecclesiastical in nature, it actually belies what they're saying in two very important respects. The first one is if you look at 216 of the record, it's Article 11, Section 1D, the section actually places affiliate churches subordinate in matters of doctrine and conduct to the GCAG. And in this regard, conduct isn't defined. The issue of control is not defined. The defendant wants you to believe. I'm
Right.
sorry?
That's the troubling issue. What's doctrine and what's conduct? And that involves different interpretation, potentially different interpretations by different courts across the country.
Right. And I think that, okay, doctrine is teaching, right? And so, I mean, definitionally, doctrine means teaching. And here, if you actually want to, one thing that I think is very relevant, I was going to point to the section on discipline, which is Article 9 in the bylaws, and how the GCAG developed a committee to determine disciplinary nature of the ministers inside and outside the churches. And in fact, Section 2A talks about the moral indiscretion of a minister and the unbecoming conduct, which we can imagine sexual abuse falls within that. And the GCAG develops a credentials committee that actually disciplines the ministers and has the ability to overrule the discipline that may be set by the district council. So I think there's a direct relation. Also involves an investigation, which we don't know if there was an investigation that was involved here. We don't know what happened because there's no discovery with regard to Faith Temple Church. So that's the first thing. But with regard to education and the doctrine that you mentioned, is that section 22, section 12 is the division of education. And it talks about the GCAG having a heavy hand in the programs and training their church leaders. It's right there in black where they train their church leaders. So I'm not sure this is that you're entangling yourself in a place that you shouldn't be able to go into if it's training its leaders. And our allegation is that Mr. Stewart was sexually abused by a member of the church during a youth program that on their website, they claim that they organize these programs and these missions. So with regard to entangling, I would just point you to a case that's cited in my brief from Onondaga County. And I think that what the court said, it's a trial court case, but what the court said, I mean, there's a Fourth Department case that I found on point. But it really, I think, it explains it very well. If I could just read you the quote, it's short. It says, it may also be, and this is the case, this is Jones against Train. It's cited in my brief. It may also be noted in passing that although defendants persistently assert First Amendment protection, none makes any suggestion that the alleged sexual misconduct of defendant Train is a part of the tenets or practices of the Roman Catholic Church, or that restraint on it by the imposition of civil liability will in any way intrude on the free exercise of religion to an extent protected by the First Amendment. Indeed, inasmuch it is conduct and not creed that underlies plaintiff's actions, and the potential for civil consequences exists equally as to religious and non-religious persons and to clergy and laypersons of all religions alike, the free exercise aspect of the First Amendment does not come into play to preclude plaintiff's actions. I think that that's exactly this case. And I think that I would ask you to take a look at the case that I cited.
We'll take a hard look at that, counsel. Anything further?
Yeah, just one last thing. With respect to the complaint, and you can look at it yourself at 137 of the record, this is the second amended complaint. My adversary says that we just discussed the GCAG's allegation, just discussed them in connection with the parties. That's actually false. So if you look at 142 of the record, plaintiff discusses the alleged relationship or that they run the programs and that they operate on behalf of the GCAG, the local churches. That's there. And in addition, there's also allegations of notice directly that they had noticed that these two individuals, Scroth and Eldon, had prior sexual abuse instances with the church. So our position is that under 3211A7 at this juncture, which is basically the infancy of the case, that it sets forth a cause of action, and that this is grossly premature. And the trial court got it right by saying that further discovery is necessary to determine the relationship so that you could be in a position to say this is purely ecclesiastical in nature.
Very good. We'll take a look at that, counsel. Thank you.
Thank you very much.
Case 511, People versus Torres.
Morning, Your Honor.
Good morning, counsel. Proceed.
May it please the court, I'm James Hobbs on behalf of the appellant Luis Torres. There are two felony convictions at issue in this case, but at issue in the appeal is only the higher one, the D felony for aggravated criminal contempt.
And Mr. Hobbs, you're focusing the court's attention on the physical injury aspect of that particular crime.
That's exactly right.
And you've cited a number of our cases that you say support your position that this is insufficient evidence.
Right.
I think your case gets a little more difficult if we go to the weight issue, but so you really just want us to focus on sufficiency. I don't mean to cut your argument off or anything. That's not my point, but I mean.
No, the primary, you're right. The primary argument is legal sufficiency.
Right.
There's the standard is substantial pain, as the court knows, or impairment of physical condition. And I just want to take a moment, it's really a record-based argument, and I'm sure the court is familiar with the record. But I just want to take a moment to talk about.
We're looking at the officer's testimony in part, right?
Sure.
With respect to the redness seen on the victim. Now, the victim didn't testify.
The victim did not
This
testify.
is part of
the
difficulty,
problem.
right?
Yes.
But the officers testified as to what they viewed, and obviously that's the testimony, and also what they heard, the raspiness of her voice. You make the argument that they had nothing to compare it to prior to hearing her voice, right?
Not exactly, Your Honor. The officers didn't. The officers actually mentioned the raspiness of her voice, but the officers did not testify to seeing any redness or anything else. The officer's testimony was that he didn't take any pictures because he's trained to take pictures of injuries if they're there, but he didn't make any note of them in the report because he didn't see anything worth taking pictures of. It's the redness, and I think if you look at it's A80 in the appendix is a shot from the body worn camera, and it's a dark photo. But if you look at it, I don't think you can discern anything in that photo looking like an injury, and you can understand why the officer didn't see anything.
But it wasn't just the officers, but
right?
The mother
and the girlfriend the friend shows up a few hours later, I believe it is. And they both say, the mother says she sees redness, right?
And they hear the raspiness of the voice consistently from the day of the event through a few days later, and it also seems to be evident on the jail calls too, don't you think?
So the raspiness is clear on the body worn camera footage, but so is and on the jail calls. The jail calls, I wanted to know, everything that came in from the jail calls is within 6 hours of the incident. It's all before noon. That's they come in at transcripts 503 to 507, and the call log is the appendix at 92. So you can look at these are calls just a few hours later. This isn't proof of an extended condition that she had. This is proof of immediate aftermath almost. And it's clear when she comes out of the house, she's in distress. She's excited, she's crying. The testimony is that there's been screaming. All of these things are consistent with having an effect on your voice. It's really hard to draw the inference that it's a physical injury to her voice, that something caused it beyond screaming, beyond crying, beyond being distraught. And it's understandable that she's distraught. She's in a fight with her long-term, not actual husband, but
They have a child.
in all purposes, they have a child together. They've been together for a decade or more.
And he apologizes on the jail call for, I'm assuming, hurting her or
Yes.
whatever, and she says her face is all messed up. Those are my words.
Yeah.
So we have to weigh all that and looking at the sufficiency, correct?
You do. I think if you focus on the two issues, of substantial pain or impairment of physical condition. These comments about my face is messed up. I mean, people can have a bruise, people can have, because I don't think that meets the standard of being a physical injury. The pain, there are cases where the victim testifies and says, you know, yeah, I had a bruise and it hurt for days. We don't have that here. We don't have either the victim testifying to any degree of pain.
So you're saying even if we find that there's evidence of redness, you know, any proof that there was redness around her neck, proof that she had a raspy voice, your argument is that the raspy voice was not necessarily a result of, the proof wasn't there that it was a result of hands on the neck?
Yeah.
Or some kind of injury there?
Right.
And even if there was a bruise on the face, that amounts to slight or trivial?
I think so, yes. I mean, it's a serious, I don't diminish the seriousness of this incident, but I don't
But
think
there's a standard.
there's a
that has to
standard
be
there
proven.
and has to be
And
proven.
that's what you're saying, that it's not met here.
And I think that even without the victim's testimony, you could have had the mother or the friend testify to some sort of impairment of condition that says, you know, I had to help her with her day-to-day activities for days. She couldn't go to work for days, you know, she couldn't do X, Y, Z, and there's none of that. We don't know, there's no evidence that it impacted her at all beyond the 6 hours into the first jail phone call. And there's just one other point I want to make real quickly is there's a mention in the respondent's brief, it's at page 10, that she reported being in pain to the police. And I don't know where that comes from unless it comes from Officer Langdon's body-worn camera footage at 5 hours and 17 minutes is where she says I'm in pain, or it hurt. That specifically is not in the evidence at the trial. The court at page 155 of the transcripts ruled that everything after 5:16:30 in Officer Langdon's body-worn camera footage is testimonial, and without her testimony, it violates the confrontation clause. So that specific point is not in there. And even if you looked at it at that 5:17 moment in the body-worn camera footage, what she says is, he says, are you all right, first of all? Do we need to get someone to take a look at you? And she says, it hurts, but I'm okay. And he says, are you sure? It doesn't have to be a big deal. We don't have to, you know, take you to the hospital. She says, I'm all right. So, you know, people can be stoic. People cannot want to involve medical care, but so I just don't think you can read much into that comment. And if anything, it leans in my favor.
Thank you, Counsel.
You're welcome.
Good morning, Your Honors. Lisa Gray for the people. I just want to remind the court that the standard for legal sufficiency, of course, is in the light most favorable to the people. And the evidence presented in this case to establish Ms. Morales's injuries went well above a petty slap or a shove. The evidence in the case established that Ms. Morales experienced substantial pain as a result of the defendant's actions. And you're right, the jury in this case did not have the benefit of a corporeal witness to talk about the pain scale on which she suffered, or the length of pain that she endured, or pain relief that she might have availed herself of after the injuries occurred. Didn't have that in this case. But what the jury did have was probably the second best evidence, which was, of course, the body-worn camera footage and the recording that shows Ms. Morales immediately after or shortly after the events took place. And she's distressed, she's crying, and her voice is raspy and throaty. And, you know, when I first listened to that body-worn camera and when I watched it, the first thing I thought to myself was, that hurts. Like when she's speaking, you can tell that hurts. It's her words kind of cut in and out. You can tell that it's labored. And she tells the police officers at 5:16:32, he was hitting me, spitting at me. He was choking me. The mom, who appears really sort of on scene almost as when the police officers arrive, she describes her observations of Ms. Morales's injuries. The red marks on Ms. Morales's neck.
Ms. Gray, just stop there for a second.
Sure.
I want to see if I've got this right from the record. At the body-worn camera, I thought I also heard he was choking me. I thought I heard the word
Yes.
choking. I didn't see where the officers testified or her saying that. Did I just miss it? Is it in the record?
So the officer did not testify to that. He did not. So when I read the transcript first, I was going on what the officer testified to at the trial. And then when I watched the body worn camera, and I think it's more clearer on Langdon's body worn camera where you can really hear her say he was choking me.
And that's within
it's
the time frame that was permitted by the court.
Yes, yes. I would just direct your court's attention to 5/16/32 to 5/16/46. So it's about, it's a real short period of time. It's a quick comment she makes. You do have to listen to it or listen for it, but it is there. Unfortunately, the officer didn't testify to that trial, but it's in the body worn camera. So again, although Ms. Morales didn't testify at trial, we have what she's saying at the time it occurred. And so again, when you look at all this evidence in the light most favorable to people, the evidence did establish this woman experienced substantial pain. And Mr. Hobbs sort of, to a certain extent, kind of minimizes, well, she only maybe experienced pain for maybe 6 hours afterwards. We do hear that raspiness on the jail calls hours after these events took place. But again, substantial pain doesn't need to be severe or lengthy. It has to kind of fall in that spectrum between more than a petty slap or a shove, doesn't have to be lasting or severe. This woman, hours after she was assaulted by her ex-boyfriend, is still laboring to get her words out. And you can hear that. You can hear that on those jail calls. And in terms of just the weight of the evidence, Your Honors, obviously the jury was in the best position to evaluate the credibility of the evidence and reconcile maybe any inconsistencies they might have come across in the evidence. And at this point, Your Honors, unless there are any other questions, I would ask this court to affirm this conviction in its entirety.
Thank you, counsel.
Thank you.
Case 512, People versus Colella. Counsel, can you hear us?
I can hear you, Your Honor.
And we can hear you clearly. Please proceed.
May it please the court, Lyle Hoydu, counsel for defendant Stephen Colella. We filed a brief in which we raised 4 separate points, Your Honor. For purposes of oral argument, I was just going to focus on points 2 and 3, which are related to the claim of ineffective assistance of counsel. We have a record here that contains proof that the attorney-client relationship was irretrievably broken. There were numerous examples of insults and name calling going on. The attorney accused the client of being a liar. The attorney characterized his client's concerns as fantasies. The attorney described the client as being a hostile person. And the attorney openly laughed in his client's face and characterized his comments as being totally absurd. The relationship was so bad that at one point the attorney threatened he was going to record the confidential communications between the attorney and your client. And this, of course, had the chilling effect of making the client no longer trust him and no longer willing to discuss.
Also, how many lawyers did the defendant have in this case before ending up with the attorney that's the subject of this this appeal?
Your Honor, I believe he had one prior attorney.
Just one?
Well, I know he had at least one, Your Honor. And my recollection was that attorney asked to be relieved.
Yeah.
Okay, but before that attorney was relieved, he did make a motion on behalf of the defendant. Why don't we talk about that a bit? The motion that he made with regard to the lost, misplaced, whatever, video that defendant claims would have exculpated him.
Yeah, yes, Your Honor. So one of the conflicts that the defendant had with his counsel dealt with that video where the defendant felt very strongly that the person depicted in that video did not match the description of the defendant, and therefore it would be exculpatory.
And it wasn't just his feelings. There was more proof than that, wasn't there, with regard to whether he was the person getting in and out of that vehicle?
Yes, because it was the officer who there was a description that had been reported, and that description did not match the description of his clothing when he was last seen by the witness at the house. So there was a.
Sure. Mr. Hyde, I didn't mean to cut you off. I'm sorry. If you want to finish your thought, go ahead. I'll hold my question if you want.
No, go ahead, Your Honor.
Okay. I noticed in the record from Officer Parisi, who I think is the author of that report, indicating that he had watched the video from the surveillance camera. Does the record have the full grand jury testimony from Officer Parisi? It looks to me that what we have is the letter from counsel to the defendant that the defendant ultimately submitted to the court, which only has like 2, maybe 3 pages of the grand jury testimony. So my question ultimately is, do we have the full grand jury testimony from Officer Parisi, or just those 1 or 2 or 3 pages of excerpts?
Judge, I'm not confident in giving you an answer.
Okay, I'll take another look at it. I didn't see the full grand jury, and the reason I raise it, Mr. Haidu, one concern of mine is, for all we know, Officer Parisi in the grand jury, for all we know, testified that the person who got out of the vehicle in the cell phone video that he recorded, or the surveillance video that he recorded on his cell phone, that person matched some other description of the defendant, height, weight, race, whatever. So that's what I'm kind of wondering. Without that, can we really evaluate counsel's strategy, if at all, with respect to that aspect of things? Maybe he knew more than the record shows, is what I'm getting at. What do you think about that?
And I don't know what the answer is, Your Honor. I recited in my brief what had been reported on the record, and it contained in the transcripts, and noting the difference in clothing, but I don't know if it went further than that. If I can resume, one of the problems here with the attorney-client relationship is, and to Justice Whalen's comments, I think the people are arguing that the defendant is a difficult client, and that it doesn't matter what attorney he's assigned, there's always going to be a problem. But I would refute that, and I want to be clear: there's no claim that he forfeited the right to counsel. That was never a claim raised by anybody, and it certainly wasn't explored by the judge on the record.
But I think, in counsel, just and I'll go back and take a look, but my recollection of the record was that once Mr. Sasha, who requested, I believe, to be relieved because of a conflict with the defendant, that the court appointed, I think, 2 other attorneys, and he did not want them representing him. I guess that's my point. So he was being difficult then, and then but he agreed to the attorney that's the subject of this ineffective assistance argument.
I misunderstood you, Your Honor, because when you said actually appointed, and I guess I'm drawing the distinction, the judge identified other attorneys before coming to the one that eventually was assigned. I don't view that as him having made the assignment. The judge floated the name.
I thought that he had assigned him. The defendant objected, and my only point is that it seems to lend to the argument that this was going to be a difficult client to handle as an attorney, and they'd gone through a number of attorneys, and the counsel here that we're now dealing with was dealing with that situation. That was my only reason for reference to that.
And Judge, I don't dispute that we have difficult clients to deal with, but unless they forfeit the right to counsel, we don't lower the standards of what that is that they're entitled to.
That's a fair argument, counsel. In other words, if they're difficult, we need to deal with it and deal with it in a professional manner, is your argument.
Exactly, and certainly if the client makes an argument, for example, that he wants to have new counsel assigned, the proper response of defense counsel is to say nothing, not to argue against it. Or if the defendant is dealing with that issue with the video and raising a claim of innocence, the remedy is to remain silent, not to argue in what would effectively be the prosecution's side of the case, saying that no, your theory of innocence is going to be rebutted by the evidence.
But in part, the argument here is, and I think Justice Kern raised this question, is there is an obligation by the attorney who's representing the client to employ what they think is the best strategy, legal strategy and trial strategy, right? And that's, they have an obligation to do that. And if in this case, there's an argument that there was a reason why counsel here just wanted to not have that video before this jury and that information before the jury, that would be that could be a possible strategy here. Limiting it to the DNA evidence, which obviously is not insubstantial, right? But the DNA evidence, but attacking that and limiting the case to that. I'm wondering, and I'll continue to look at this as to whether or not that's not a legitimate strategy.
And Your Honor, you're jumping back to ineffective assistance of counsel as demonstrated through the lawyering. And what I jump back to is regardless of the lawyering, regardless of how good it was, there was a fundamental breakdown in the relationship with the attorney and the client. And that's a fair distinction.
Yep.
Well, that's a distinction I make, Your Honor. So unless you had any other questions for me, I'd rest on the papers.
Thank you, counsel. Mr. Hillary?
May it please the court. Michael Hillary for the people. This record struck me as a situation where defense counsel was dealing with a very difficult client, and it called for firmness. When you listen to what Mr. Haidu presents, certainly examples that he sees as signs of an irretrievably broken relationship, it doesn't sound good. But when you take into this picture, this defendant, how he was with prior attorneys, how the court viewed his behavior, theatrics, gesticulations in court when conversations were happening.
But counsel, if I may, the issue in my mind isn't how the defendant acted here, but how counsel acted. And I'm struggling to understand what the strategic advantage was to the defendant to withdraw that motion. And the defendant says it was withdrawn without consulting with me. That motion had a good chance of success, didn't it?
Judge, by withdraw the motion.
The omnibus motion. Yeah.
I'm sorry?
The omnibus motion.
Well, I think we have to look at the situation in totality.
I think just to focus in, that's what the defendant says was ineffective. I didn't authorize that. You withdrew the motion. Had that motion proceeded, that would have helped me at trial.
Well, counsel didn't see it that way. And I think this goes to whether or not there's a reasonable strategy that this court can discern instead of what defendant would have had counsel do. The reasonable strategy that leaps from the record here is very simply synopsized in nobody could put defendant near or in the car. Nobody. The only thing that could put him in the car theoretically was DNA proof. And counsel, of course, spent considerable time during cross-examination of the expert trying to undermine the reliability of that DNA proof.
I'm sorry, let me tell you, that would have happened anyway. That DNA proof was coming in. But as I understand it, this video that was lost or destroyed might have shown that it wasn't the defendant who got out of the car, it was someone else. So that would have only added to defense counsel's strategy that it wasn't the defendant who stole this pickup.
Well, what counsel did with respect to the video, of course, was to say, we don't know what the content of the video is. The sheriff's department reviewed it, but never provided a copy, never were able to go back and record it and present it to the people who then in turn could have provided it to the defense. We don't have the advantage of seeing it. So we're going to preclude or move to preclude any use whatsoever of the video. That I believe was reasonable. If we don't know what the content of the video is, it could just as easily be said that it would have been damning to the defendant or confirmatory of his involvement. I'm
In
sorry.
what way? If it showed somebody wearing different clothes than defendant was wearing, how could that have been damning to his position?
Well, it wouldn't necessarily have been damning to his position at that point. I think this goes to what the record really reveals about that particular alleged fact. I think counsel, Justice Curran, you were asking, if my memory serves, about the record support for that in the grand jury.
Officer Parisi's testimony in particular, because my concern was, I'm not even sure we're in a position where we can evaluate whether it was a matter of strategy, because we don't know enough in the record about what counsel knew.
That's
where I was going on that, but
yes, Judge, and that's true. We're kind of at a disadvantage either side to argue that, and just how strong or weak that evidence could have been.
Considering that he was going against his client's wishes, very well known to the lawyer that his client did not want him to withdraw that motion. Very vociferously told his lawyer not to withdraw the motion. In light of that, we have a lawyer who then goes rogue and does it anyway. And we don't know whether or not, what the strategy possibly could be. I'm straining to find a strategy that would have taken a tool away from his lawyer at trial, that even based on the weakness of the evidence, could have given a charge saying, look upon this suspect, the evidence is gone. Like, wouldn't that have greatly helped the defendant? And I don't see any strategy that would have helped him more.
And I would have to speculate, Your Honor, in all fairness, to put myself in the position of a defense attorney and come up with a reasonable strategy. But I would suggest, and the court can decide whether or not this is a fair point to make in the circumstances. Defense attorneys have at their disposal multiple theories to present to a jury. Oftentimes, those theories can be conflicting or self-defeating. I think a wise attorney sometimes settles on one instead of multiple, because to present multiple to a jury will signal to the jury that something is wrong with the better one. And all I can suggest to the court here is, if the better strategy is nobody put him in that car, nobody put him near the car, but we do have DNA, which to a near mathematical certainty, it seems, puts the defendant in that car, to stake a claim to the fact that, hey, this person in the video had different clothing. A jury would be likely to find that as, I think, a little bit maybe casuistic, maybe overly sophisticated. People change their clothes. People remove clothing. He did a trek through the woods. It would have been approximately 1 mile to 2 miles between the Crump Road address that he fled from and where the vehicle was that he absconded in. The jury could easily have looked at these as conflicting approaches by defense counsel and found the whole thing to be simply a bridge too far.
Right. But counselors, I understand this. What the attorney did was he traded the motion for this stipulation. Right. He did that without talking to his client. He did that against his client's wishes, as I see it. And the benefit to the client from that stipulation, the video was gone. It was lost. It had been in the possession of the police and was gone. I'm not saying what did he gain through that stipulation that would have outweighed what he would have potentially gotten had that motion been decided by the court.
I don't know, Jeff.
Right.
I really can't answer that to my own satisfaction.
The stipulation was, I think, to the effect of they will not discuss the video at trial. How could they have possibly discussed the video at trial when they lost?
Right. Well,
he didn't gain anything with that stipulation, did he?
Well, we, the people, could not refer to the video in any sense. I mean, there was a background.
Couldn't anyway, because it was gone.
It was gone. Right. Now, I mean, theoretically, someone could have attempted to allude to the fact that there was a video, and even with nothing more, it would have caused a jury to speculate, well, he was on video, even though there would maybe counter proof to that. So I think counsel felt no side can really know enough to make a lot of headway, but I don't want to take the risk that it even gets suggested to a jury that such a video existed and lead them to speculate down a path I don't want them to go down.
Mr. Hillary, let me take you briefly to the DNA evidence. A defense counsel, if I recall correctly, actively cross-examined the expert, right, on the DNA.
Yeah, that's my sense of it.
That's how I read the record. but, and if it's in the record somewhere, I just don't know if it came in the evidence at trial. Was there some reference to the defendant allegedly going up and down vehicles on the road from which the vehicle was ultimately stolen? That is, at least he was like trying to get into cars to get change or something like that? Or was that part of a different motion? Is that in the record at trial or not? I'm thinking it wasn't, but I just need to confirm that, man. I'm drawing a blank.
I don't remember that in
Okay.
the record, Judge,
I'll look-
but I will defer to the court and
I'll
their
answer my own
investigation of the
question.
record.
Fine, no problem. I'll look at it. Thank you.
Anything further, Mr. Hillary?
No, Judge, thank you.
Thank you. Case 513, People versus Everson.
In person. Good morning. May it please the
Proceed,
court.
counsel.
Brad Keem for Mr. Everson, the appellant. We submit that the people mischarged the offense and as a result failed to provide legally sufficient evidence that Mr. Everson intended to kill. The Court of Appeals has said that shooting into a crowd is a quintessential example of a depraved or reckless act, not an intentional one. Here, even in a light most favorable to the people, Mr. Everson is driving while shooting into a park. Between him and Bordes, an estimated 16 shots are fired indiscriminately into a group of 20 people. Everson's statements after the shooting, "Did you see someone drop?" indicated he had no idea whether he hit anyone. He was not aiming at anyone. This is not black shell relied upon by the people. There's no evidence that Bordes or Everson knew that their supposed enemies would be at the park. Instead, it's a careless and random shooting from a moving car into a crowd of people. And I think at sentencing, the fact that this was a mischarge is amply demonstrated when the prosecutor herself said Everson and Bordes didn't care if they struck anyone. They didn't care who they struck. That is depraved indifference. That is not intent. We'd ask, therefore, that the court is constrained to reverse the murder 2 and CPW second counts because the people failed to prove intent.
Counsel, would you address your argument with respect to severance?
Yes. So in regard to severance, the defense counsel basically warns the trial court. Defense counsel for Bordes is going to blame my client for this act, and he does just that. He points at him in summation and says,
Co-defendant's counsel makes reference, if I've got this correctly, makes reference to defendant's girlfriend's testimony.
correct.
Which
Highly.
ultimately points to the defendant.
Correct. Yes.
And why does that lead to an argument that there should have been a severance here?
So we assert that severance was appropriate there because it so separated and created a risk that at that point, co-defendant counsel was a second prosecutor, encouraging the jury that this is Mr. Everson, and Mr. Everson who did this, encouraged them to find him guilty of the charge.
Counselor, did Mr. Bordes' counsel put in any evidence that your client was the shooter?
Your Honor, he did not put in any evidence. It was a summation argument.
That's the sum of the argument here is that he commented on evidence. All the evidence of the defendant's guilt was presented by the people, wasn't it?
And Your Honor, I think the important part though is that defense counsel for Everson warned trial court that this was going to happen. So I think at that point, the trial court needs to make.
But to be clear though, that Mr. Bordes' counsel didn't take a prosecutorial stance at any time. You don't even argue it until his closing argument.
I don't, Your Honor. So it would have to be based on the summation, but I think it's so strong. I'm literally pointing at the defendant saying he is the shooter.
Well, just be careful. Just so I understand this though, he's saying, as I understand it, the evidence indicates there were 2 guns fired. We got 45 cal, we've got 9mm cal shellings on the ground. And the witness in the back says 2 guns were fired. So the co-defendant says it wasn't me. It had to be the two other guys in the car. That's the essence of your position, that the co-defendant was a second prosecutor.
It is, Your Honor.
And counsel, just again to clarify that issue, with respect to the statement of the girlfriend, presumably if you were to win on the severance issue, there'd be a retrial. And that evidence still comes in. But your argument is, but if it's severed, there's not another attorney in the courtroom in summation adding to the argument that the prosecutor's making, doubling down against your client.
That's exactly it, Your Honor. And I believe that summation it's powerful stuff. When you read it, it truly is. And I think it could have changed some minds in this case.
It was powerful when it was said by the girlfriend as well, okay? And wouldn't this comments be just, in closing, be a fair comment about the evidence that was presented?
I think it went beyond fair comment whenever you're pointing at someone and making that argument in such a vociferous manner. In fact, I might have called that prosecutorial misconduct if it is made an argument, made a different interesting prosecutorial misconduct argument in this case, but I certainly may have added that to it.
Mr. Kim, I mean, here the proof came in identical against both defendants, correct?
Yeah,
Right.
for the most part.
I mean, there was no other proof other than what the prosecution put in, and it was put in against both defendants. So it's the same proof as I understand it. So in that situation, the case law would say you have to have the most cogent reasons to sever, right? So that's the standard. Would you agree with?
I would.
Okay. So with that, there's also cases, including Mahubian, or how you pronounce that from the Court of Appeals, about some degree of prejudice is of course inherent in every joint trial. And there's also appellate division cases that expand that a bit and say some degree of hostility and prejudice is inevitable in every joint trial. So when you don't have competing evidence, so typically as I read these cases, it's like a co-defendant puts in proof against the other defendant, or both defendants blame each other. But you don't have any of those factors here, including in, and I'm going to mispronounce it again, Mabuya, whatever it is, there the defendants testified, as I recall, sort of against each other. So that's what I'm really struggling with the severance in this one. This just doesn't seem to, and then you got the Clark case, of course, about the single comment. I've looked at that the single comment was lesser than it is here. And also the comment about the girlfriend, the people made that point in their closing in any event. And they of course were going to, they called her as a witness to a direct statement from the defendant. So, I mean, how do you come up with the most cogent reasons in this case?
Yeah, so I understand the struggle the court is having, but I would point to two things. One is defense counsel warned the trial court and the trial court didn't inquire at all. Maybe we would have a better record. And two is just the vociferousness of the actual summation by defense counsel for Voorhees.
Thank you, counsel.
Morning, Your Honors. May it please the court, David Bassett for the People's State of New York. Turning to the sufficiency of the evidence, our position is that there was sufficient evidence to show that defendant intended to cause the death of another person as necessary to support murder in the second degree. And that was supported directly by the testimony of the primary witness, James Ellerby, who was in the car with the defendant and the co-defendants, saw them fire a number of shots into a crowd. And the fact that it's a crowd does not preclude a finding there was intentional murder. There is case law out of this court in People v. Archie that you can still intend to kill someone in a crowd, even if there's others around them. And why was there an intent here? Because they were shot at 2 days before by people in this neighborhood. The people adduced evidence at trial. There's a neighborhood dispute going on, a feud. Defendants drive to that rival neighborhood. They fire a bunch of shots, 11, 12, up to 16 shots into a crowd. One of the people, Jameer Gillard, is wounded and later dies. Defendant says to the guys in the car, "Did you see somebody drop?" I would submit that does show that he was expecting someone to drop, that he intended for somebody to drop. Therefore, we submit that there was sufficient evidence for intentional murder. As to the severance issue, we would take the position that these defendants were properly joined. They were accused of the same charges and acting in concert. As the court recognized, all the proof applied equally to all of the defendants. And the fact that the co-defendants counsel made certain comments at the closing did not show an irreconcilable conflict as is required under the, I think, Mahubian case in the Court of Appeals. The Court of Appeals said that irreconcilable conflict has to be the reason why the jury infers the defendant's guilt. Here, there's a boatload of evidence to infer the defendant's guilt. There was, as I said, the girlfriend's testimony, James Ellerby's testimony, ballistics testimony, video camera evidence, all of which pointed to defendant as pulling the trigger. And as opposed to—
Counsel, is it your position that when this was raised initially before the trial to the court, that the courts did an adequate inquiry relative to the possibility that one defendant was going to point to the other defendant?
Yes, Your Honor. Our position is that the defendant bears the burden under the statute, under the case law, to show good cause for severance once defendants are properly joined, as was the case here. The defendant made a motion to sever, which is completely insufficient. It just referenced a statement by Bordes, which did not even mention defendant Everson. And then at a pretrial conference, he says, well, I think co-counsel is going to try to shift the blame towards my client. It doesn't say how, doesn't explain what kind of evidence he might put on, doesn't show anything.
So you're saying that there was not, the burden wasn't carried to even have the court do it, have an inquiry as to whether or not there was enough there.
Correct. It's up to the defendant to show good cause.
Yeah, and you're saying that they failed on that, and therefore the fact that there wasn't much of an inquiry is the defendant's fault.
I think the court fairly said, well, your arguments here are speculative. You know, you're not giving me enough information. I'm not going to hold a hearing as to what the evidence might show. You've got to give me something to show a conflict, an irreconcilable conflict between these two defenses. And here we have both defendants proceed along the same lines in their questioning of the prosecution's witnesses, trying to basically say that during the case that these witnesses aren't credible. And they didn't testify, they didn't put on any evidence of their own. And then in closing, the co-defendant's counsel does make some comments that tend to shift the blame towards Everson, saying that it's more likely that Everson and the Ellerby character were the shooters. But summation is not evidence. That was instructed to the jury, and what the evidence showed, what Ellerby's testimony showed, what Lacey's testimony showed, what the ballistics evidence showed, and the video evidence was that defendant Everson and defendant Bordes were the shooters. And it's worth noting that Bordes made this big argument in closing. His client was still found guilty on all counts. Therefore, we believe—
My concern, Counselor, too, on this, and I'm not sure it would hold water, but just to say it out loud, that if we say that severance should have been granted here by virtue solely of the comment made in closing pointing the finger at the co-defendant, that's an invitation to do that all the time. I mean, the comment I mentioned earlier about from the case law, hostility in joint trials is sort of assumed.
Mm-hmm.
You know, the number of drug offenses we have that's found in the living room, and one person says, well, it wasn't mine, it was that person's, etc. This could come up a lot if all we do is point to the closing statement and say that's enough to require severance.
That's correct. I don't think that you should be grounds for to overturn a conviction just because co-defense counsel says something in closing.
I thought you might agree with that. So, but what I want to address is Mr. Keem's point. Does it matter when it's done where there's a warning that we're going to do it, and this vociferousness, I think might have been the word in closing in terms of how it's said. Does that matter under the law?
Not as it stands, Your Honor. I believe that there needs to be a showing before trial. The defendant bears the burden under this court's jurisprudence in the Bennett case and under Mabubian and the statute as well. The defendant bears the burden to show for trial why these cases should be severed. Let's keep in mind there's a dozen witnesses, tons of evidence, jury has to come in. The whole point of keeping this trial together for joinder is judicial economy and avoiding having to do this twice.
But counsel, didn't defense counsel bring it to the judge's attention? The judge denied it, and then it came up at the closing.
Our position is that although he brought it to the court's attention beforehand, he didn't do enough to explain how that was going to be a material conflict that would unfairly prejudice the defendant. And nothing happened during the course of the trial that would amplify that argument that he made before trial until closing. There was no evidence that conflicted. And I think that is what is required. You can imagine, I think as the court pointed out, a witness, co-defendant testifies, well, it wasn't me, it was you, right? I mean, that's the kind of situation we're looking at. Or another witness put on by the defense during trial that shows an irreconcilable conflict. And that was not done here. They did not meet their burden. Therefore,
I don't want to belabor the point. I do agree with your assessment. But as your opposing counsel said, one of the attorneys said, I know one thing for certain. There's two people in the car, two guns were fired, and I know one of these persons shot the gun.
I'm not condoning the comments that co-defendant's counsel made. I'm simply saying that that is not grounds to overturn this conviction and would not be grounds for severance under the law in this court's jurisprudence.
We'll take a look at it.
Thank you.
Thank you, counsel. Case 516, Bizisco versus Fleming. Counsel, proceed.
Good morning, Your Honors. Amanda Nelson of Cozen O'Connor for the appellant, Rochester City School District. Central to this appeal is the issue of what notice the school district had 50 years ago. Whether it had notice that the teacher, Fleming, had a propensity that would result in him sexually molesting students, and whether the school district had notice that further supervision of this particular plaintiff was warranted. To address the latter first, plaintiff was an excellent student. She, in fact, graduated early with a Regents diploma. On top of that, she seemed to have a good relationship with the teachers and students in her school, including Mr. Fleming, who she invited to her wedding a month after she graduated. So there was nothing to put the school on notice, to put the district, on notice that further supervision would be required beyond what they were already providing. As to Mr. Fleming, the school district presented substantial evidence that there had not been any notice of any improper activity, any sexual assault before the incidents involving plaintiff. We did this through several teachers as well as through a union representative. On top of that, even the plaintiffs themselves acknowledged that they, for example, BL Doe 3, never, quote, witnessed, heard about, or saw Fleming be inappropriate with other students. BL Doe 5, who not only was a student, but then eventually worked for the school district, said that she did not see him being inappropriate with other students. That's at 545 of the record. So here we have two different high schools. You have West High and East High, which are veritable rumor mills. And there was still nothing for the district to be on notice that he was engaging in improper sexual acts with these students. In support of the order, plaintiff relies heavily on what BL Doe 5 testified. Another teacher, Moses Cofield, said to her in 1969, after school hours, off school grounds, in the sense that he told her, oh, I know what's going on. You should be nice to me, and himself tried to kiss her. This is extremely problematic for several reasons. First and foremost, we have no idea what he thought was going on or what he was conveying was going on. In fact, when BL Doe 5 was expressly questioned about whether this was something that was sexual, she said, I don't know, it wasn't specified. For all we know, it just as likely could have been he overheard a conversation about BL Doe 5 taking Fleming's hall passes and forging them, which she had mentioned that she would do, and which she would presumably not want to get out. Or Cofield could have just been essentially making it up, having heard from Fleming what was going on, and used that himself to try to sexually molest the student. So from the get-go, we're really relying on speculation to say that he even had any knowledge of improper relationship, improper activities by Fleming towards BL Doe 5. On top of that, it's also inadmissible hearsay, which does not get around the inadmissibility through the amended CPLR 4549 because the plaintiff still didn't meet the burden of showing that the statement was made during the course of Cofield's duties. It clearly was not. It was after hours, 9 o'clock at night in a park while he himself was attempting to assault BL Doe 5. Beyond the inadmissibility itself, it simply is not knowledge that can be imputed to the entire school district. Much like this court considered in Pater versus Buffalo, you can't just have one teacher having whatever knowledge he had.
What do you make of, counsel, if I could interrupt you for a second, what do you make of, counsel, the testimony that, for example, he would have some of the students, female students, ride on his back and, like through the hallways, which is not behind closed doors, is not off school campus. That seems to me to be conduct that if a parent were there, might question and ask, what are we doing here?
Certainly, and I have no doubt in my mind that especially in 2024, same thing with the hugging, that
The prolonged hugging is how it's, it went on too long. And the references to him being very touchy-feely, uncomfortable touchy-feely. I mean, these are all, it seems to me, indicators that if you're stepping in the place of a parent, you are going to say, we need to look into this. And as you know, as you've referenced, we've got a number of these cases that we've heard the argument out. And so, but I'll give you the opportunity just to answer that.
Sure, absolutely. And to that point, I think it's crucial to look at Miss Watson's testimony, particularly at page 662 of the record. Certainly no friend of Fleming. She didn't like what he was doing. And what she believed that she saw around, I believe, 1980 or 81. But at that time, she acknowledged, look, this was how things were then. This was not anything exceptional, and it was not even considered inappropriate for there to be a quote unquote occasional pat on the butt, which certainly today there would be no question that that is inappropriate behavior. So I think we do still have to remember that we're in the position of the early 1970s and what was perceived then as problematic or acceptable versus
so
now.
your suggestion is in the 70s, were a parent of one of these young women in the hallways and seeing this conduct, it would have been fine. They wouldn't have had a problem with it. That's your argument?
I think that appears to be what the testimony reflects, and that what the testimony of the students themselves reflect, to the extent that they say they did not see improper conduct or inappropriate conduct.
Okay, we'll take a look at that. Anything further, counsel?
Great. If the court will indulge me for a moment, I just want to make clear that particularly in addressing, BL Doe 3 statements, BL Doe 5 statements, there's no intent here to cast blame on any of these young women. We're not blaming BL Doe 5 for internally shutting down when the psychologist tried to ask her, why do you not want to graduate? Nor Bieldo 3 for not being clear or not saying outright I was inappropriately touched. It really just comes down to that without that sort of specific direct statements, the district simply did not have any knowledge.
Thank you, Councilman.
May I please support John Bonsbach with co-counsel Christopher J. O'Brien for plaintiff Victoria Vasico. First, one of the comments I just want to start with had to do with that the conduct that happened here would not have been problematic in the 1970s, but today it would be an issue. I believe that goes to the very core of what is a question of fact that a parent of ordinary prudence, whether it's in 1974 to 77 when Victoria Vasico is being abused, or a parent in 2024, how they would have reacted to seeing whether it's girls getting piggyback rides in the hallways, whether it's their hair being stroked, they're being kissed on the cheek, the long hugs. I think in the record, you've got the photograph of the one senior student sitting on the teacher's lap while the teacher has his arm around a second girl who's holding onto both hands to keep his Fleming's hand from doing anything further. I believe that goes to the question of fact that a jury should decide, and that whether the lens of 1974 to 77 is that different from today. I guess that's perhaps for a jury to decide. To the Moses Cofield statement in, and I apologize, I know Justices Whalen and Del Conte heard this on April 8 to some extent, but first we believe that under the Kirshner versus KPMG case, that it's clearly the statement of an agent that should be imputed to the principal, because there is, excuse me, no indication here, and I think even the school district would agree, that Cofield's actually intended victim is the school district. When Cofield says, I know what's going on in the back office of the music room, you should be nice to me, is he trying to harm the school district? I suspect probably not. I think he's probably trying to gain some advantage over plaintiff Bieldo 5. So that's the first thing. The second thing is that the Kirshner case talks about there has to be actual harm, which is defined as short-term detriment to the school district as a consequence of the agent's actions. There's no short-term harm here, and but for the passage of the Child Victims Act in 2019, we wouldn't be here today. So there's no basis for not imputing Cofield's notice to the school district. And this idea that it's too imprecise, when he talks about the back office of the music room, I know what's going on. What would a juror infer from that? It doesn't even matter, because unless the agent's intention is to harm the principal, it doesn't matter what his intent is. It still is imputed. With respect to the fact that they're arguing that it's hearsay, CPLR 4549 has two tests. It has to be, it's not hearsay if it's by the opposing party's agent or employer on a matter within the scope of that relationship and during the existence of that relationship. The statement that Cofield makes to Bieldo 5, that I believe was the Highland Park Reservoir here in the city of Rochester, when he makes that statement, he's talking about something that happened inside a school building during school hours, while another school district teacher and a school district student are in that back office of the music room. The fact that the statement is said at a park outside of school hours to another student doesn't change that the statement relates to a matter within the scope of his employment, that he had a duty to supervise.
Does it matter the reason why he's making the statement?
I don't know why he's making it. It certainly would suggest that he's making the statement because he wants her, he tries to kiss her after he says that he's trying to gain some advantage over her. But his intent under the Kirshner case is unimportant. Why the agent did something doesn't matter unless the agent intended the victim to be the principal. And that's restatement of agency law. That's what the Kirshner court says is important, because the school district, as the person that hires this teacher, that employs this agent, they're in the best position to select the agent and to train the agent to act honorably. There are no policies or procedure. There is no training in the record of anything the school district did to try to protect its students or to train its teachers how to respond when you suspect there's sexual abuse. And if Moses Cofield had perhaps been told, listen, You hear another teacher did something wrong or another student did something wrong. You go to the principal. You don't keep it to yourself. You don't try to use it for your own advantage. It would seem that you shouldn't even have to train something that fundamental for someone who is obviously a well-educated person. But nonetheless, there was no training or instruction or policies or procedures. And so the agent was disloyal. That doesn't defeat the imputation of the agent's notice to the principal, to the school district.
We'll take a look at that.
Thank you. On the hearsay issue, this is a quote right from the Unified Court System website, the Judge's Handbook on Evidence. It says that federal courts have given the phrase, this is the, on a matter within the scope of that relationship, have given the phrase a liberal construction requiring only that the statement have some connection to the agents of the employee's specific job duties. Teacher Cofield had one, as part of his job duties, an obligation to supervise students, their safety. Clearly, it's within the scope of his employment for that purpose. And then
So let me just understand that argument. You're saying because the scope of his duty was to protect, to keep safe the students, that when he's off premises and he's, let's assume that we conclude that he's using this information for his personal benefit, he's trying to get educated, right?
Right.
You're saying that that action, because it jeopardizes the safety of the student, becomes a non-hearsay statement.
It's not the statement, it's not to whom he says it, where he says it, when he says it. It's that he acquired the information that the statement relates to during the scope of his employment.
Okay. I understand it.
Okay, so he clearly, if he had been a good agent, a proper loyal agent for the school district, he wouldn't have told the student this. He would have gone down to his principal and said, "Hey, this is what I think is going on in the back office of the music room. I don't know if it's true, but I think it concerns me. Let's look into it, please." He didn't do that. His motivation and why he said it, whether he was trying to warn her, "Hey, I know what's going on in the back office of that music room. You should be careful of whatever you're doing back there. It sounds like something funny's happened." Doesn't matter under either Kirshner or under 4549. 4549 doesn't talk about the motivation of the person making the statement. And again, this idea where the statement was made, it's in a park. It's not on school grounds, but 4549 doesn't say that the statement has to be made in the employer's or the principal's place of business. The fact is the information that the statement relates to was acquired during the scope of that relationship.
We'll take a look at that, counsel. Anything further?
Yeah, I would just one last comment, which was this idea that Plaintiff Victoria Vasico invited Edwin Fleming to her wedding. She did not. It was her husband's mother. Thank you, mother-in-law. Nothing further, Your Honor.
Thank you. 519, Tuttle versus Keller. Proceed, counsel.
Thank you, Your Honor. May it please the court, Ryan Mills for appellant Kip Keller. Your Honors, this matter arises out of an automobile accident, February 15th, 2019. Significant here is it's a rear-end automobile accident. Plaintiff is the passenger in a van that's traveling with a driver that is intoxicated or under the influence of.
Counsel, let me interrupt you just for a
Yes.
second to kind of ask maybe a more procedural question on this case. We're talking about a spoliation issue and a PJI charge to the jury. And I know this may be a little bit catching you off guard, and we, don't mean to do that, but I certainly want to hear from you. Is this premature to bring to this court? Is this not in the nature of a motion in limine that proceeds to trial and then comes up to us?
That's an interesting question, Your Honor. We would submit because the trial judge found any spoliation at this point in time, that it's appropriate to be in front of Your Honor. We submit that there shouldn't be any spoliation finding at all here.
Mr. Mills, just to follow up on the presiding justice's question. Under 5701, I forget the subsection, it doesn't matter at the moment, but most of our appeals come to us when it affects a substantial right or involves the merits. That's what gives us jurisdiction to review the order on appeal. So that's sort of the tether that we say, does that exist? Because of that tether, using my words, doesn't exist to show that this order involves the merits or a substantial right, then we don't have jurisdiction. We can't do anything. And see, one of the concerns I've got is, and I know we're catching both sides off guard, and we don't know what to do here. I think, at least I don't. But it strikes me as it's almost, if you on an order granting a motion limiting, we will review it if it affects a substantial right vis-a-vis, such as it effectively grants summary judgment on a cause of action. That we review. That sort of dispenses with the claim you're not going to be able to try it. So it's been determined. Here, it seems to me this could end up being tried about what happened with the adapter. And what if all of a sudden the testimony comes out that it was willful? I know that's not the way you think it's going to come out. What if it's that it was just an oops and it wasn't even negligence under the law? Could the court undo? I'm sorry to ramble, but I'm going to give you
I
all these thoughts in one.
Yeah.
Can the court undo it at trial?
No, that's interesting. Yes. No, I understand.
Here's what we'll do, because we recognize that we're catching maybe both counsel off guard on this issue, wasn't briefed. If you would like, we would certainly give you an opportunity to submit something post-argument on that discrete issue.
Yes. Yeah, that would be great.
That'd be granted to both counsel if they wish to take advantage of it.
Okay. Thank you.
Why don't you proceed with your argument?
Okay. Okay. So back to the automobile accident. We've got this rear end automobile accident. Plaintiff is a passenger, injured in that accident. At the scene, at issue is this adapter. So we've got this tractor, manure spreader set up, and then this adapter that's connecting the two of them. The adapter is arguably damaged in the accident, and then it is detached by the Scott Blossom volunteer firefighter at the accident. The sheriffs test it at the accident scene, hook it up to a battery, which then proves that the lights work. They put that in their accident reconstruction report, that it's operational, and my client was not cited with anything at the accident scene.
You pretty well know the facts, Mr. Mills.
Okay.
I'm sure you appreciate in
Yes.
terms of the background. Again, I don't mean to cut you off, but it seems to me that the preservation letter is your biggest obstacle with respect to this thing. I mean, you get it plus or minus 35 days after the accident. Even under the testimony or the response to the notice to produce, where your client says, yeah, it's gone, and it's been gone since 2 to 3 months after the accident, which is suggestive of the idea that it came in, that it was destroyed or allowed to go away, whatever it was, after the preservation letter. So, I mean, that's really kind of what we're focused. We know the facts of the accident, we know the background of how this got here, but isn't that your ultimate problem? That is, you've got the preservation letter, you're teed up, you're supposed to preserve it, and your client didn't.
Sure. So to the preservation letter. So the preservation letter indicates the tractor and the manure spreader. We've got this adapter between the two of them. Does that constitute a key component of the tractor and the manure spreader? One of our arguments is no. If that adapter was so important, it should have been specified as an adapter, because different attachments can be utilized to connect those, and there wasn't anything specifically.
But counsel, wasn't that adapter to draw power to the lights?
It was,
To
yes.
the back of the spreader?
Yes.
So wouldn't that just make it germane that that's something that should be preserved?
It certainly was important, but again, it was tested at the scene. The police were able to test it at the scene. My client then took it back, used it for a period of time, and then ultimately disposed of it. Yeah. We would submit that there is no prejudice here either, because their expert was able to still, based upon photos, render an opinion, as was our expert. And really, there was no evidence here of any spoliation.
Thank you, counsel.
Thank you.
Good morning, it's Michael Steinberg, for the plaintiff here. We were essentially moving for something that was tantamount in a way to summary judgment, because we were moving really to take the entire issue out of the case.
You move to strike the answer and for determination of liability, or at least negligence or proximate cause, depending on the serious injury issue, but who knows where that is, whatever. But so you may have a different wrinkle, Mr. Steinberg, with respect to the appealability issue.
Yes.
I just don't know. But you seem to appreciate that.
I was new to me, but I'm trying to be quick on my feet, and I will certainly put in a post-argument submission. There are some really serious things I want to point to, though. The first, and this is an error that the trial court fell into, is the claim over, and we get this again. I don't know why no one listens to me, but that the adapter was tested. The adapter wasn't tested. If you go to page 151 to 152 of the record, the person who saw it said they took a battery and they hooked it up to the manure spreader. Now, what had happened in this accident is that the two had become detached. The main part of the adapter is bolted onto the tractor, and it pretty much stayed intact. There were wires that fell out. There were wires that were torn between the adapter and the manure spreader. And so there were bare wires hanging out from the manure spreader, and the police attached those bare wires to a battery that they had. Don't know why, but maybe to give people jump starts. They attach it to the battery, the manure spreader lights go on, they say, aha, the lights work. But that doesn't answer the question that we needed to answer, which was, did the adapter work? Was the adapter getting power to those wires? We don't know. We'll never know. And when in our cross appeal, when the trial judge said, well, yeah, it was inconvenience, an inconvenience to the plaintiff, but it didn't destroy his case because after all, they tested it at the scene. And his expert could talk about that. Well, it wasn't tested at the scene. That's why this was so important. It was so important for the plaintiff to ask that it be preserved. And the idea that
what do you say to the question that it wasn't asked to be preserved? It wasn't mentioned in the preservation letter, specifically the adapter.
I think that's really going beyond what seems obvious to most people. It's part of the assembly. The plaintiff asked that it be preserved in the same condition. And to preserve it in the same condition does not mean unbolting and removing part of it. And that actually plays into the other part of our cross appeal, which is the idea that somehow this was negligent. You can't negligently dispose of something that's bolted to something you're required to preserve. You have to go out there with a wrench. You have to take it off. You have to put it someplace. And the defendant admits that it was disposed of. I love the passive voice, some mistakes were made. It just vanished on me. It couldn't have vanished on him, and it couldn't have been negligently done. As long as he knew that he was under an obligation to preserve this in the state it was at the time of the accident, it can't be a negligent act to remove it. And in fact, he says, well, I reconnected the wires and I used it for a while. So there is clearly here a deliberate act, and it doesn't have to be, we've cited case law, it doesn't have to be an act saying, I'm going to destroy this. To inconvene, to destroy the possibility that I'll be found liable. No, simply, if you do it deliberately, it's a deliberate act, and far more serious sanctions are called for. And in this case, we think it was inappropriate for the court, an abuse of discretion, to say that I'll just give a permissive charge that the jury can draw an adverse inference. Here we have notice. We have deliberate destruction of something which cannot be analyzed, which was never tested, which doesn't give us the information we need to decide. This is a case where in a prior accident, the lights weren't working. It is really a live question whether they were working or not. And talk about the intoxication of the driver doesn't remove that from the liability calculation.
Anything further, counsel?
Just a point. I kind of messed up discussing the Smith case, which defendant cites. I'm not going to back off from anything I said, but I looked at it again yesterday. I said, wait a minute. The Smith case, which talked about the theory of liability. The Smith case was not a notice case. There's no indication in that decision that the defendant was asked to preserve the records that they disposed of. Doesn't apply here where there is a notice, and we submit that the notice obviously covers the entire assembly, and what we have here is deliberate spoliation.
Thank you, counsel. Case 520 Novak versus Western New York Snowmobile Club of Boston, Inc.
Morning.
Morning, counsel. Please proceed.
May it please the court, I am here on the appeal involving the Snowmobile Association and the plaintiff. So my appeal deals with the application of General Obligations Law 9-103, which I know the court is well familiar with. The title of that statute is No Duty to Keep Premises Safe for Certain Uses. And there are many Court of Appeals cases that talk about the intent of the statute. It confers absolute immunity from liability to an owner or occupier of land who allows people to come onto that land to engage in certain enumerated recreational activities, including snowmobiles. And in this case, we believe that the lower court denying our motion erred in two specific ways. Number one, in finding that there was a lack of suitability for this property. And number two, finding that there was an issue of fact as to whether there was willful and malicious conduct. As to the suitability issue, the Court of Appeals has held that suitability must be determined as a question of law. But here, the court found that while the snowmobile trail was overall suitable, she focused on the very small portion of the trail that crossed over a road.
That's where the accident happened.
Correct. Okay. And so focusing on that one area, she found that that particular area was permanently unsuitable. And it's our position that that is an inappropriate application of the statute. If you look at Bragg versus Genesee Agricultural Society, the Court of Appeals held, if the language of the statute is to have any force, suitability must be judged by viewing the property as it generally exists, not portions of it at some given time. There's 13,000 miles of snowmobile trails in New York. There are hundreds of places where those trails cross roads. In fact, there is a statute, Section 25.05.3 of the Parks, Recreation, and Historic Preservation Law specifically allows trails to cross roads as long as they do so at right angles and as long as there's no obstructions, and neither of those issues is at issue here.
Counselor,
Go ahead.
I'm sorry, Judge Bain.
I was just gonna say, wasn't it part of the plaintiff's claim that they couldn't see that the roadway was up ahead until they were just about in it? And so the claim was about signage and notice that they were about to enter a roadway. Does the statute apply to, destroy those claims?
So If I may just finish the suitability issue, and I think that goes to whether or not there can be willful or malicious conduct attributed to a failure to warn. So with respect to the suitability, that statute not only talks about how you cross a road, knowing that trails are going to cross roads, but it also sets out rules for the snowmobile drivers. They're supposed to be careful. They're supposed to stop before they get to the roadway. They're supposed to yield the right of way to automobiles. So,
Counsel, let me, if I may, I guess I didn't read the plaintiff's argument that way, because your client is not the owner of the road.
they're an occupier.
You occupied the road?
They occupy the trail.
Just the trail, right?
Correct.
But once you leave the trail and go into the road, you're in the public highway. Okay, as I understand it, the argument is that the trail itself is unsuitable because it lacked the signage. So that the operator of the snowmobile would leave the trail and therefore enter an unsuitable area. And that's the contention here, isn't it? That the failure to warn someone you're about to leave the trail and go onto a public road.
The trail is the crossing of the road is part of the trail. So it's included as part of the trail.
I understand that that's the way it's shown on the maps, but the club doesn't satisfy the statutory definition, does it? The club doesn't own the road, doesn't lease the road, doesn't occupy the road.
The club is considered an occupier of the trail.
Right.
And the trail goes across the road.
Okay.
So the scope of the club as an occupier of the property over which the trail
Because
passes
the statute,
includes.
the way you get to the road is you go to the Parks and Historic Recreations law that says snowmobilers can cross roads. If you follow these rules, cross at 90-degree angles, stop before you cross the road, it is perfectly lawful for a snowmobiler to cross the road. And that's on the rider.
Right, but it also talks about the trails crossing the road. And it also specifically talks about how a trail can cross a road. And it's supposed to be at a 90-degree angle and there can't be an obstruction. So that's specifically addressed in the statute. So the statute contemplates there are going to be snowmobile trails that cross roads. And there are in fact hundreds of them all across New York State. There are many
Without
trails.
crossing roads, there really would be no
There'd be
mobile trails.
You could go up and down and up and down and up and down, but you could never go on the other side of the road. And we know that they do all the time. Also, in reaching that conclusion, the lower court totally ignored the plaintiff's testimony that he had been riding snowmobiles for 20 years. He lived near this area. He testified that in fact, he was on this trail at least half a dozen times every year over the last 20 years. And most importantly, he testified that he had downloaded the state snowmobile map, the GPS app on his phone. He had mounted that phone on the dashboard of his snowmobile. He did that so that he would always be able to see it. He said in his own words in his deposition, he was familiar with this trail. And if he had that app on his dashboard, he could see all of these trails. He could see that it crossed the road. And in fact, this trail crosses the road in two different places. On page 8 of our reply brief, we actually have a screenshot of it.
So that's a whole different argument, that because the plaintiff already knew where the trail ended and crossed over a road, that there's no duty for you to tell him about it.
So this goes to the warning issue. So as far just to wrap up suitability, it's our argument that this road was suitable. The fact that the trail crosses a road does not make it
Counsel, I think
unsuitable.
we had that argument. Why don't you move on to the warning issue?
With respect to the warning, a failure to warn, a regular garden variety failure to warn does not give rise to liability under this statute. The statute requires willful and malicious conduct in order to impose liability. And that's, the Court of Appeals has held this many times in Bragg, Farnham versus Kittinger, Cutway versus State of New York. They're
Let
all
me ask you a
cited in
question.
our brief.
If a snowmobile club, which takes it upon themselves to set up the stop signs, the yield signs, the trail direction signs, right? The clubs do this on their own to to facilitate the areas that they're covering on the overall trail maps that go across county jurisdictions and everything else. If they put the signs up, do they have a responsibility to periodically check those signs that they continue to be up? Or once they put the signs up, they've done their duty?
So we would say, first of all, that the case law specifically holds that there's no duty to warn at all. But the snowmobile clubs do warn. There's unrefuted evidence in this record that those signs were put up. Mr. Novo, who was in charge of putting the signs up, testified that he had been doing this since 2007 for all these years. Every fall, he would go on this trail, he would put the signs up, he followed the guidelines in the book that said you put up a stop ahead sign, you put one stop sign, he put 2 stop signs. This is unrefuted. It's also unrefuted that he said he only lived 2 miles away from where the accident happened. So 3 to 5 times a week, he would just go over there to make sure that the signs were there. If a sign had been defaced, if the sign had been removed, if it had fallen down, he would either repair or replace it as required.
The proof is in the pudding, isn't it, that the signs weren't there?
No one said the signs were not there. That's another thing. The
Okay.
plaintiff testified he did not see the signs. But when he was asked, are you saying that the signs aren't there? He said, I didn't see the signs. So this was at night. So the fact that the plaintiff did not see the signs doesn't mean that the signs were not there. There's no proof the signs were not there. There's only proof that the plaintiff didn't see them.
And as I understand sort of the argument, it's almost in a way, Supreme Court seems to have made a finding in its decision that it's permanently unsuitable. This portion, that is where it crosses the road. In a way, that takes away the whole Albright-Cummings issue, because that is what I call a temporal distinction versus the spatial distinction we made in Cummings. So the temporal will be, hey, if the argument is that the signs were not there on this particular day because they'd fallen down, somebody took them out, whatever it is, it would still have general suitability from a temporal perspective vis-a-vis Albright and Cummings. Therefore, the plaintiff would seemingly lose if the argument is they were temporarily missing. I think that's why Supreme Court maybe either went a step too far or maybe did exactly what the plaintiff wanted to do. I'll ask the plaintiff, but it seems to me your argument is this part where it crosses the road has general suitability as defined in Albright and Cummings. And any argument that the signs were down on that particular day is a temporal, time-related argument that doesn't affect general suitability.
Correct.
Am I close?
It just looks at the portion of the road on that particular day. And there's absolutely no proof in this record that the signs were never installed. At most, the proof might be, if you give the plaintiff the best inferences he's entitled to, that something had happened to the signs since the last time that Mr. Nova had gone to check on them. Also, Jeremy Neff, who's the president of the Snowmobile Club, testified in his deposition that the groomers, and you got to remember, these are all volunteers. So these volunteers who go out on grooming machines and they make the trails nice and neat, they carry extra signs with them. And if they notice that a sign is down, they will replace the sign. So all of this, we believe, goes above and beyond what is required under the statute, because remember, the cases hold, they're legion. There is no duty. There's no ordinary negligence duty. There can only be liability imposed for an accident that happens on one of these trails if the conduct of the defendant, the Snowmobile Club, was willful and malicious. And I just want to close.
You should wrap up, yeah.
We've cited cases in the brief, and I just want to mention a couple of them. In Gardner versus Owasco Railway, the defendant intentionally erected a barrier on the road, built out of ice and snow to keep the snowmobiles slow. No liability. This court in Bowles versus Kawasaki, the defendant intentionally put logs in a culvert and the dirt was swept away and they rose 6 to 8 inches above the surface of the road, took out a motorcycle, no liability. In Sabia versus Nimo, there was a gate, no warning provided of the gate, right adjacent to the trail. The snowmobile rider smashed into the gate And this court reversed the lower court's denial of summary judgment to the defendant. So there's no indication of any willful or malicious conduct. The plaintiffs didn't know anybody in the snowmobile club, no reason for them to try to harm the plaintiff. At most, assuming they had a duty to warn, we have a failure to warn, no liability under the statute for
Thank
that.
you, Counsel.
Thank you.
Proceed, Counsel.
May it please the court, Dale Bauman of Lipsitz Green on behalf of plaintiffs. Judge Bannister asked a question at oral argument, and I didn't hear a clear answer to it in response. The question was, when there is no warning present to an individual that is being directed by the snowmobile club into what we can all agree is the hazard of a 45-mile-an-hour road, is that sufficient to let the snowmobile club off the hook? We submit it is not. In this case, there is no proof, and there's certainly no admissible proof on the motion that for the duration of that season, a stop sign or warning sign as is required by the Office of Parks was in place. I say no admissible proof because there's an issue on the appeal that submitted as inappropriate affidavit of Mr. Novoa on the responding papers, which raised new issues for the first time. This court has consistently held, following its decisions in Zuckerman and its progeny, that those attempted corrective actions on a reply paper are inappropriate and should not be considered.
Counsel, I think you're on this point, but if not, forgive me, I'm taking you another point, but would you concede that your client testified that he did not stop before crossing the road?
My client did not stop before crossing the road. He also testified clearly he had no indication that there was a road. In fact, his testimony was, I first knew there was a road when there were headlights immediately to my left, and then he was struck.
Okay, so on that, if I read your brief correctly, part of the thing I was going through with your opposition there is, as I read your brief, you're saying it's the absence of a stop sign or a stop ahead sign or both, or one or the other, that rendered this property unsuitable at the time your client went over. I don't see you making an argument. Forgive me for not letting you interject, but just so I finish the thought, I don't see you arguing, according to what Supreme Court found, that it is permanently unsuitable and they should just loop around the road. So I don't read your argument going to permanent unsuitability. I read your argument as temporary unsuitability based on the absence of the signs. Do you agree?
I agree to a point. The distinction is, as in Your Honor's decision in the Cummings case, that was a temporary position that, or a temporary condition that was there for, I think, 24 hours. What we have a situation here is an accident that occurs in February of 2018 and testimony that signs were placed at the beginning of the season, which I believe would be November or so of 2018. Our point is more active. They've actively created a trail that leads directly to this hazard, and there's no evidence or documentation that signs were in place. Certainly on that day when my client and his son both passed by, and by the way, were asked, did you see a sign? Answer, no. Are you sure? Answer, I did not see a sign from both of them. I think that that raises a clear inference that far from being temporarily temporal, there's no proof that there was any signs there beyond what happened at the beginning of the season.
Well, there's photographs in the record that show the stop signs. There's testimony in the record that the stop signs were routinely placed there and were routinely observed there by those, the gentleman who testified when he went by there. So again, I'm at the moment, I'm looking at, you're saying they happened to be down this day and that rendered it unsuitable.
All photos that are included in the record were from 3 or 4 years post-incident, and there's testimony that the arrangement has changed in those intervening years. There is no photos or documentation or any testimony at all that there were signs present that day. And because
Counsel, let me, just so I understand your argument. Do I misunderstand the testimony then that the snowmobile, the gentleman that would drive by there, daily, I guess, or a number of times a week, and would check to see whether, I mean, if you're driving down the road and if you're familiar with the stop signs, presumably you can see them as you drive down the road. So we have testimony that's not years after this, but it's about what happened before the accident, that there were checks on that particular stretch that confirmed that the signs were in place not in November, but at around the time of the accident. And if they weren't in place while he was checking it, he would take steps to put them in place. Do I misunderstand that testimony?
No, you don't. And the testimony was that it was my habit that should I pass a sign and see it done, I would fix it. Absent is any documentation, record, recording, inspection, that actually
It's
occurred.
still evidence though.
It is evidence,
Yeah,
and on summary judgment, I would submit it raises a question of fact as to whether or not it occurred. I think that in my favor is
You'd
the
like a
fact-
jury to hear the testimony and be able to cross-examine the witness.
Certainly, yeah. And ultimately, what we have here is, and I think plaintiff's testimony bears this out, I'm traveling through a tunnel of trees in what his son describes as medium or moderate snow. On the other side of the tunnel of trees, or on this side of the road rather, is another tunnel of trees. I'm traveling through with no indication that I'm being directed directly to a hazard. And as Judge Del Conte said, a hazard directly off of the trail onto a 45-mile-an-hour roadway. On those facts.
Would you disagree with your opponent's characterization that are you saying that the trail ended? And I'm not even sure it's an important distinction. I have to think about that. But that the trail ended at the roadway, then there was the roadway, and the trail began again? Or is it a continuous trail as it crosses these roadways with the proper signage?
I would say that where this defendant has the burden, there's no proof in the record to demonstrate that they possess or own the portion of the trail that traverses that roadway. And so they can't rely on a supposition that they do. Read in conjunction with the state regulations with regard to how to cross a roadway, I think what they're doing is they're directing trails that have a trail on one side of the roadway and one on the other, how to connect those two, generally at 90 degrees across the roadway. I am not aware, and I wouldn't expect to find an agreement between the trail and New York State somehow transferring control of the trail, trails that cross over roadways to the trail and from the state. That would be news to me, and I would submit news to defendants as well. If the court would like me at this time to address the claims of the car accident, Mr. Wilkins.
You should do that.
Those are addressed concisely in our papers. This one is perhaps a more standard issue that appears before the court. It's a question of fact. The question of fact is, I have an expert whose expertise was merely to measure the distance, the sightline distance of the intersection, an intersection that's marked with a standard green sign for oncoming traffic. The testimony is that given the 300 plus feet from where that sign would come into view until the accident occurred would be an elapsed time of 5 seconds. Defendant testifies that even though it's snowing, and again, we have proof the snow was medium or moderate, he was traveling just slightly below the speed limit of 45 miles an hour on an incline on a road that has a curve in it. There's minimally a question of fact as to whether his actions in doing so were a proximate cause of the collision, not necessarily the proximate cause of the collision. Otherwise, I'd rely on my papers.
Thank you, counsel.
Thank you.
May it please the court, Dominic Shamara on behalf of defendant respondent Wilkins. Just a few things I want to really highlight from the argument you just heard. It is a 45-mile-an-hour road. It's uncontroverted that my client was going below the speed limit. The plaintiff did not stop before entering the intersection. He didn't slow down before entering the intersection. His testimony was he didn't know what he did before entering the intersection. All of a sudden, he just was in the intersection. Then, perhaps most importantly, you heard it's a tunnel of trees. It's a tunnel of trees on both sides of the roadway where this trail exists. It was a moderate snowfall. What you didn't hear and what's in the expert report, and I will put expert in quotes, expert report is that there's also an embankment there that obstructs a snowmobile rider's view of oncoming traffic at that intersection. The expert did point out that there would have been 320 feet of unobstructed view for my client as he's traveling down Boston Colden Road to the intersection itself. He doesn't say that it's an unobstructed sight line to snowmobiles traveling down the snowmobile path. He doesn't say that he had any ability one way or another to see or not see a snowmobile coming. He doesn't offer an opinion on that. His only testimony with regard to the accident itself is the defendant had 5 seconds of unobstructed view of the intersection itself. Now, the case law is very clear. I don't have to keep beating you guys over the head with the same case law over and over again, but my client's entitled to know, or to, with the right of way, to believe that other riders are going to obey the laws of the road. And unless you can show that he acted negligently,
I have a
given the
question,
conditions.
and this
Please.
might not make any sense, but snowmobiles aren't silent. There's no, they make a lot of noise, okay? Is that play any part in giving some warning to the driver that snowmobilers are in the very area where he was, and maybe he should use a little more caution?
That, I don't believe that argument was ever addressed before the court. I don't believe that was ever addressed by the expert.
So let me ask you this one, okay? Besides their not being silent, they usually have lights on. And even though there's, stands of trees and, would that make a difference to, could your driver have possibly seen lights flashing through the trees and approaching the intersection?
Oh, well, I guess I'll answer your question with a question. Could the snowmobile driver have seen the headlights of my client's vehicle?
There's no questions here, Counselor. We asked the question.
Sure. The answer, I'll answer for you. The answer is no. The snowmobile driver testified that he didn't see headlights from my client's vehicle until it was feet from him to his left. So I think it stands to reason, and I put it in my papers, that if he can't see us through the same conditions with headlights, through the snowfall, that the papers say that the snowfall would have been illuminated by the headlights, which I think is a speculative argument. But even if you give him that credit, he didn't see us. And now he's asking us to see him, who enters the roadway against the right of way. The case law says if you are traveling with the right of way, you still have to, you can't just proceed blindly into an intersection. But if you are given no time to react, and there's the recent Gomez case from this court last year, if you're given no time to react to someone violating the right of way,
So the
you're not
emergency
negligent.
doctor.
Correct. Yeah. So I don't believe there's anything that was offered that shows there's a question of fact that my client was acting negligently. He was traveling below the speed limit, given the conditions. I don't know how slow they wanted to go. They didn't say if he was going this slow, he would have been able to avoid the accident. They don't offer any proof to that matter. Just he should have been going even slower. So with that, rest.
Thank you, Counsel. Case 521 and 522. Restataris Construction Corporation versus Norfolk Southern Railway Company, and my apologies on the pronunciation of plaintiff's first name.
Good afternoon, and may it please the court. My name is Timothy Fry. I'm here on behalf of the appellant, Norfolk Southern. Norfolk Southern appeals 2 orders consisting of a combined 4 motions that really only present one true question on this appeal. And that is whether it is proper for a declaratory judgment claim to be used to seek an adjudication of rights that are actually already pending and in ongoing federal litigation. Consistent with this court's decision in Florence, which is in accord with other decisions at the appellate courts in New York, Norfolk Southern submits that it is not the proper use of declaratory judgment actions to seek that type of relief. This case arises from a
Counsel, let's just set the stage here. So
Yes.
the state court action was filed first.
There was an action that was filed between Restataris, the plaintiff.
Right.
And-
Our case was filed before the federal case.
Correct.
Right.
As against Norfolk Southern and a third party that's not here today.
And so Norfolk Southern, after the state case is sued, then sues the surety in federal court.
Correct.
Right. So RCC is not in federal court.
Correct.
Right. So when RCC brings the motion to amend its complaint in state court to add a cause of action, RCC is not participating in the federal case.
That is correct. But that's where I think you would have to look at the actual language of the complaint that was being sought to be joined, the count that was being joined in the state court proceeding. And if you look at the language of that complaint, and that's at the record at pages 156 to 157, the third cause of action that's being added, it specifically seeks relief on behalf of Philadelphia Indemnity. It's not seeking relief as between Recitaris, RCC, I'm going to say RCC because I've mispronounced the name myself.
Right.
Between RCC and Norfolk Southern, it's seeking relief of really the surety's obligation to Norfolk Southern. It specifically asks that the surety's liability or obligation be vitiated. And so when you look at that, I think you see that what is happening here is it's using the declaratory relief mechanism to seek relief, really, which is already pending in federal court. And going back to what I was saying, right, there are two lawsuits, as you correctly note. There was the state court action that was initially brought between RCC and Norfolk Southern and a third party that's not here. And that action addresses the specific dispute between RCC and Norfolk Southern. Here, Norfolk Southern was seeking to have a building constructed on its site. And because of issues and safety violations, that did not occur. And so any issues between RCC and Norfolk Southern are properly already before the Supreme Court in that action.
Just a moment to set the stage, though. RCC says that after we filed our action, you then, Norfolk, sends us a letter formally terminating the contract under section 3.7 of the contract, which would be, permissive or voluntary termination. And if you do that, we don't have any cover costs or no obligations to Norfolk under the circumstances. And that's what they say the subject of the third cause of action is in the amended complaint.
I think, again, I would point to the actual language where it's seeking relief and actually saying, please find that the surety is not obligated. And that's really the language of the third party complaint, the third cause of action. Any issue as to whether it was termination for cause, which is what Norfolk Southern believes, and it listed 13 different reasons in that letter right before identifying the only termination cause in the contract, the construction contract. It's not a normal AIA contract. Any issues as to termination for cause, whether it was termination for convenience or wrongful terminations, those are already presented in the state court action by way of either RCC's original complaint seeking a breach of contract or implication of the duty of good faith, or as a defense to Norfolk Southern's counterclaim in that same action, where it's saying, because of the egregious safety violations, you materially breached this contract and you owe us the cost to complete this project. If that's the case, then there is no need for a duplicative declaratory judgment action anyway. And that in and of itself would be consistent with cases that talk about declaratory judgment should not be granted where it is not necessary. Since those issues are already presented by way of actual claims for money damage, there's no need for a duplicative or mirror image declaratory judgment claim. And that's similar to the declaratory judgment claim that Philadelphia seeks to bring by way of intervention. Whether Philadelphia is allowed to intervene by right or by permissive intervention procedurally does not change the substantive issue of how it's seeking to intervene. And that is by seeking a declaration of the rights, seeking essentially an advisory opinion from the state court of the claims that are already pending in the federal court action. And the lower court recognized that the precedent of this court and other appellate courts is that a declaratory judgment should not be used in this manner, but it did so anyway. The lower court spoke of the typicality of these types of causes of actions in construction cases. But there's no case law that's been presented in either the lower court or an appeal talking about typicality being the standard for whether a declaratory judgment is allowed. There's no body of law that's presented and said in construction cases, you're allowed to do this, whereas you can't in other cases. And that's precisely because if you allow a declaratory judgment claim to be submitted after another cause of action is pending in a different court, you're essentially undoing the federated system of courts. There's obviously inefficiency with having a federal system of courts. There is a possibility of parallel litigation. And that is what the federal court found when Philadelphia sought to move to dismiss the federal court action. It applied the Colorado River Doctrine, which is a complicated doctrine that we don't need to go into today. but essentially said, yes, these two cases, because of the similarity of the claims, the similarity of the parties, are parallel litigation. Now, I don't know what will be said after I leave the podium, but I assume that there'll be some mention of the allegations that were raised by Norfolk Southern in that federal court case. And obviously, we were arguing in that case to try to keep the case in that court and talking about a distinction as to what is parallel when it's applied to the Colorado River Doctrine. Ultimately, the federal court found, yes, these are parallel litigation. They are substantially similar claims raised by substantially similar parties, which is the exact criteria for either a dismissal of the deck actions in the lower court, or as we present, never actually allowing them to be allowed through the amendment or through the intervention.
Counsel, you should be mindful of your time.
Thank you. As I mentioned in my reply brief, I think the appellees are in an unenviable position of trying to defend a lower court decision, which actually quoted from precedent that holds against it. They ultimately ignored the actual issue here, and that is the improper use of the deck action. They try to bring in factual issues, which are not actually right for adjudication or not proper on this appeal. There was recently a summary judgment filing that was made despite the fact that we're at the very early stages of discovery. I'm not sure if that'll be raised or not. But ultimately, whether or not the liberal standards for amendment or for intervention are applied, whether there is a justiciable issue, which of course there is because Norfolk Southern filed a case in federal court, do not ultimately change that using a deck action in the manner in which it has been used by the lower court or approved by the lower court is improper. And for those reasons, if there are no other questions, then Norfolk Southern will submit it on its papers.
Thank you, Counsel.
Afternoon. Joe Manna, Lipsitz Green for Recitaritz or RCC. You know, when I'm surprised that this is the thrust of the argument, quite frankly, because to me, this is like a no-brainer. I put this case into suit. At the time, I alleged two causes of action. One was breach of contract. The other was breach of implied duty of good faith and fair dealing. In the original contract, we alleged that there was a breach of contract and a de facto wrongful termination because Recitaritz had been prohibited from doing work for months and months and months. And then after the pleading stage ended, the next day, we get this termination letter addressed to me invoking section 3.7 of the contract. That poses a problem for Recitaritz because a convenience termination, as you all likely know, is not a breach of contract. And if you invoke a convenience termination, there's no looking at the duty of good faith and fair dealing that's implied in every contract. So if the motion to amend had not been brought, had not been granted, I'm looking at a situation where very conceivably there's no breach of contract and there's no breach of the duty of good faith and fair dealing, but there is a dispute as to the type of termination that took place. If you were to ask counsel here, was it a convenience termination? I don't know if you'd get a straight answer on that, but the amendment brings that to the forefront. I have asked the court to declare that there was a convenience termination for two reasons. It eviscerates the counterclaim. It also invokes rights to Recitaritz to get paid for certain things. And as a happy ending to it, it also vitiates the bond claim. And my client is injured by a improper, wrong, I was trying to grasp for a professional word, bond claim.
I'm sorry, but it seems like in any event, it's sort of like a breach of contract because of its convenience termination, and they don't pay you what should be paid based on that convenience termination. That is in effect, I coming up with the idea of some form of breach of contract. I suppose it could be unjust enrichment if you get off the contract, but you sort of did a belts and suspenders approach here and said, you know what, I better protect myself and make sure I ask for declaratory relief on that. So that I also, in case it's not breach of contract, I have some relief coming my way if I succeed.
Yes. That's simple, Judge. That's simple. And I'll conclude because I know you've all been listening to people for a very long time. You know, this notion that we've somehow interfered with the federal court litigation, that's rolling along just fine. The court made a decision in the federal court case. I'm sure Mr. Baum may talk about it, you know, basically saying, hey, you know, if there's a decision in the state court case before we decide and it's adverse to you, Norfolk Southern, well, guess what? That's a collateral estoppel problem for you. So I think the federal court got it right. I think Judge Walker, you know, he got everything right as far as I could see. And unless there's any other questions, I'll
No other questions, counsel. Thank you.
Good afternoon, Ted Baum, Adams LeClaire for Philadelphia Indemnity Insurance Company. We also believe that each of Judge Walker's orders should be affirmed. The intervention issue, the motion to intervene, I'll address first. In that motion, in opposition or on the appeal, my adversary has suggested that the Ithaca Textiles case says that there's a rule that the state court should not be permitted to proceed with a declaratory judgment where we have the pending federal action. But there's a couple of things to consider. One is Ithaca Textiles says that the chronology is not the sole test. And as Judge Del Conte pointed out, the state court action actually existed before the federal court action was filed. And that's of some significance here. So what are the factors that this court should consider? Well, one, Recitaritz is not a party to that federal court action. And all of the allegations that discuss whether my client has exposure rise and fall on the allegations as against Recitaritz. So why not handle all of these disputes under one roof? Judge Walker said these issues are inextricably intertwined. Judge Wolford in the federal court, I know it's not a part of this record, but it's available for all to see on the court's website, said that these two cases are parallel and that there would be res judicata collateral estoppel effect in either court. And one last thing is whether or not you permit Philadelphia's motion to intervene to be upheld, this case in state court is going to proceed. There, with respect to the motion to dismiss, I think Judge Walker put it best, not much had changed in the weeks that transpired between the motion to intervene and the motion to dismiss. But in any event, Judge Dillon has observed in the practice commentary that under 3211A4, a dismissal on those grounds is always going to be discretionary and not mandatory. Judge Walker exercised his discretion. And only if this court finds that Judge Walker abused his discretion in doing so, should it reverse his determination. So simply stated, these combined appeals are about one thing. Did Judge Walker abuse his discretion when he granted the relief that was sought by Recitaritz and by Philadelphia Indemnity in these motions to amend and to intervene? And I would submit to this court that in light of the finding that the facts of the Recitaritz claim against Norfolk Southern, the Norfolk Southern claims against Recitaritz, and the Norfolk Southern claims against Philadelphia are all inextricably intertwined, Judge Walker's determination was perfectly appropriate. And both of Judge Walker's orders should be affirmed.
Thank you, counsel.
Thank you.
Case 523, 524, Neal versus Monroe County.
Your Honor, he is checked in, but he is not online, and we did reach out and he didn't answer.
Very good. We'll deem it submitted.
This court contains